I think it's very hard to overcome the 50-50 and without really concrete evidence. In my opinion, the judges are going to give you your day in court.
Right.
They're going to let you call your witnesses, and you can call the lady from the pickup drop off line that you were always the parent picking up and dropping off. And they're not going to cut you short. Do think, though, from my personal observations, unless they're going to hear substance abuse, domestic violence, hanging out with maybe a criminal element, exposing the children to an unstable, unsavory living environment. You're gonna have to have some harder facts. It's not like I said, it used to be, I would say 70-80% of the case was who historically for the child, who historically cooked breakfast, who picked them up, who did homework with them, how those responsibilities were divided. Now, though, with the presumption, you got to have a lot more than that. You got to come in really with your evidence laid out and to be taken serious. That's my view of it.
I really feel in the last year, all the cases that we have been involved in and went to testify in with evidence, we've seemed to have really good, I want to say, a feeling from the judge is taking in what we're what we're offering, what we're providing. It really seems to me that we're giving the judge a reason, if needed, for something to be changed in the parenting plan other than 50-50. But
Well, what I think is this as a lawyer, I think of myself sometimes as like a contract. A contractor can't build you a nice house unless you're willing to pay for the 2x4s, the
right,
tile, the cement, the nails, the screws. I think of myself, the more I practice, is more like an architect or a composer. I'm going to draw out the plan, or I'm going to, kind of run the orchestra of the band here. It may be that we need a private investigator early on. It might be that we need somebody who does like forensic accounting